Good afternoon, everyone, and thank you for joining us for today's webinar, which is Nonprofit AGMs in Alberta, One Size Doesn't Fit All. My name is Jennifer. I am the Manager of Communications at Integral.org. We are going to start today's session with a land acknowledgement. We would like to acknowledge that Integral.org is based out of Mohkinstsis, which is the Blackfoot name for elbow. This refers to the confluence of the Elbow and Bow rivers that run through Treaty 7 territory. Mohkinstsis is the traditional territory of the Blackfoot Confederacy, which includes the Siksika, the Piikani, the Kainai, as well as the Stoney Nakoda First Nations, consisting of the Chiniki, Bearspaw, and Goodstoney First Nations, and the Tsuut'ina First Nation, and the Métis Nation of Alberta, District 5 and 6. We have a long way to go in addressing the tension between the legal and governance structures that we work within in the nonprofit sector and efforts towards truth and reconciliation. We at Integral.org accept our responsibility to work toward reconciling this tension. We commit to remaining in a position of humility as we consider our history and current reality, knowing that the answers are not clear and easy ones, yet they require all of us to engage. We all have a connection and responsibility to the lands that host our lives, our communities, and our work. It is my pleasure to introduce the presenter for today's session, Yvonne Chenier. Yvonne is a lawyer and philanthropy consultant and co-founder of Integral.org. She brings more than 35 years of experience helping those in the philanthropic, nonprofit, and social enterprise sectors as general legal counsel and as an advisor on organizational, regulatory, and governance matters. And Yvonne, thank you for being here and sharing your expertise with us today.
Thank you, Jennifer. Thank you for hosting and facilitating this important seminar. And we have an hour together today. So I'm going to speak quickly, and Jennifer's going to be monitoring the chat. So she's going to interrupt me if there's any questions that I should discuss or answer as best as I can while I'm doing the presentation. But we will have time for topical questions after the slide presentation is done if we get through it. As Jennifer indicated, the slides will be available to you after. And most of these questions, and I see I've got my overview slide up here, most of these questions I have dealt with many times in the legal clinics that we do at Integral.org. Organizations come with these questions, and we methodically go through for their specific organization the information that we're presenting today. So if you're not getting what you need out of this webinar today, you certainly can come to a free legal clinic at Integral.org, sign up on our website, and at the end of the presentation, the information is there, and we can go through your specific questions about your organization and where you are incorporated under to answer all your questions. But today we're going to talk a little bit about AGMs. What's the same about AGMs, annual general meetings, and what's different depending on your incorporating statute? What are the timelines? What are the notice requirements? And what, importantly, are the voting rules under each of these statutes? We're going to talk now about virtual and hybrid meeting and bylaw provisions, things we weren't even talking about years ago. And how do you update those bylaws, and how do you ensure compliance with your bylaws and your AGM rules requirements? And at the end, I've got a whole bunch of slides on practical strategies for smooth, effective AGMs that you can follow. And let's get right down to it. So the first thing I'm going to talk about is what is the same about annual general meetings and what's different in your incorporating statutes. So what's the same? the big thing that is the same with all annual general meetings and nonprofit statutes that we deal with here in Alberta is an annual general meeting is a meeting of the members of your organization. It's not a board of directors meeting. This is very clear that you have to get that right up at the very front. Members are the ones who come to your annual general meeting. And why? They're exercising their votes and their rights as members at these meetings. And things that they do, some of them do, and we'll go over what has to happen at AGMs and what often happens at AGMs and some of the procedures. But generally, you're electing your directors, you're receiving your financial statements, you're reviewing activity reports from your board of directors, your committees, your executive directors, your staff, and you're voting on resolutions. That is the ultimate right of a member, is to vote and have your vote count. So that's the same, and that's the only thing that's the same across all of our statutes. An AGM is an annual general meeting of the members. So it depends on what has incorporated your organization. So I'm just basically going to refer to the three major ones that we avail ourselves here in Alberta when we incorporate a nonprofit organization. There's the Alberta Societies Act, which probably most of you are incorporated under. Then there's the Alberta Companies Act, Part 9 for nonprofit companies. Yes, it's still a thing in Alberta. Some of you are incorporated under that, and some of you may be incorporated under the most modern statute in Canada for nonprofit organizations, and that's the Canada Not-for-Profit Corporations Act. It's very important that you know where your birth certificate is. What legislation was your organization incorporated or born under, because that affects a lot of things about your organization that I talk on many seminars and other places, but today I'm going to talk about how it affects your AGM rules. Why does it matter what incorporating legislation you were incorporated under? Well, there's different rules about timing, the notice periods you need to give your members, what kind of electronic meetings and voting you can have, what financial disclosures you need to give to your members. And maybe this seminar might convince you to review the statute you're incorporated under and think about making a change potentially. Or if you are new to the sector and you want to incorporate under a nonprofit statute, this specific session might give you pause to consider that one of these statutes may be better suited to the organization that you are going to incorporate. And you might, want to go to one of these statutes as opposed to the other. So that you never know who's attending and what kind of ideas you're taking away. And for each of these organizations and each of these statutes, to a certain degree, the bylaws or the articles under each of these acts that you incorporate under may allow you or indeed may impose some additional and unique requirements for the type of organization that you are incorporating. So you have to be aware of all of these things. It's not as simple as one should think it should be. After all, what is it? We're just holding a meeting. Okay, Jennifer, go ahead. First question.
Sorry about that. Yeah, there's a very relevant and common question, which is, do charities govern under a different statute?
That is a very good question. And no, charities are, charitable status is a status given under the Income Tax Act to organizations that qualify to be charities. What we're talking about here is maybe the first step to creating an organization, and that is the incorporation. So you don't have to be incorporated to be a charity. That's another session we would have at Integral.org, or indeed talking about it at another time. But most organizations, for various legal reasons, incorporate. So first you incorporate under a statute. And in Alberta, the most common ones are the Alberta Societies Act, the Part 9 of the Companies Act, or the Canada Not-for-Profit Corporations Act. So I hope that answered the question. Being a charity is just a status. But incorporating, that's a birth certificate. So there, think about it that way. So under the Societies Act, when do you hold an AGM? Well, the Societies Act simply says in Alberta that you have to have your AGM annually. That's all it says. And why? Well, because they're looking for a financial statement that sets out the income, the disbursements, the assets and liabilities, audited and signed by the society's auditors, must be presented to the members. So usually you do financial statements annually, so you should present them to the members annually. And your notice requirements and everything else about your AGM is in your bylaws if you are an Alberta society. You won't find anything else in the Societies Act itself, except that you must have an AGM annually. The Alberta Companies Act, if you're incorporated under that, has a different rule. You must have your AGM within 16 months of incorporating, and then every calendar year, but you cannot delay more than 16 months after the last preceding general meeting that you had. Different rule. Um, the notice period that you have to give to your members is specified in your Articles of Association, which is sort of like your bylaws under that act. They're just called Articles of Association. And if you don't specify that in your articles, then the act provides that you must hold your AGM at your registered office the month after your incorporating anniversary month. So very rigid. So most organizations put this right in their articles. Under the Canada Not-for-Profit Corporations Act, you have to have your AGM, your first AGM within 18 months of incorporation, and then every 15 months thereafter. However, and this is often a tricky one for some organizations, the AGM must be held within 6 months of your fiscal year end. So that's an important time frame, depending on what your year end is under that legislation. And if it's tough for you to do that, you can't meet the 6-month deadline, or indeed you can't have your annual meeting for various reasons, then you can apply to the minister, the Canadian minister, for an extension, which happened quite a bit during times like COVID, for example. And the Act, Canada Not-for-Profit Corporations Act, specifies that you give 21 days minimum, up to 60 days notice to your members, your directors, and your auditors. So as you see, when you hold an AGM, it's not rigid, is it? It depends on the statute. It depends on what you put in your bylaws or your articles of association if you're incorporated under that legislation. Here's a fun one. Where do you hold your AGM? Well, under the Alberta Societies Act, your bylaws may provide where you hold it, or your bylaws may state that the directors, or indeed sometimes the members, dictate where the AGM is to take place, what location. Under the Companies Act, again, you put it in your Articles of Association, and if you do not put anything in your Articles of Association, such as that your directors will decide where to have it, then you have to have it at the registered office of the company, which is usually a law firm or a small office somewhere, could be your office. Who wants to have an AGM at your own office? So put something in your articles if you're a Part 9 company.
Just a quick question, Yvonne, kind of in relation to previous slides.
Okay.
And that is, can an AGM be done with directors only?
Well, remember what I said, an AGM is for the members of your organization. It's not for the directors. However, some people have organizations in Alberta where the directors and the members are the same people. They're the same people, but the members have a different status under their organization than the directors. So if you are having an AGM and the same people in the room are actually the directors, they're actually taking their hats off and putting their members' hats on when they're having an AGM. So I see this often in organizations where they don't quite understand the difference between what members have to do and what directors have to do in organizations. And we have done many seminars on that, and I'm happy to do more on that very, very important legal differentiation between members of an organization and directors of the organization. Directors govern the organization. The members don't govern the organization. They often just elect the directors. So hopefully that helps. So, you might think you're a director, but one day you're actually a member going to a members meeting. If in fact your bylaws allow you to be directors and members at the same time. It's not something that just happens. It has to be in your legal document.
And
I,
in related
mhm,
news,
mhm.
can others outside the members
Ah,
slash directors
mhm.
attend an AGM as
Yeah.
non-voting attendees?
Okay, we're going to get to that slide. I'm going to talk
Okay.
about who can come to an AGM. So we're talking about where to hold an AGM still, and we're just finishing off with the Canada Not-for-Profit Corporations Act, which is very specific. You can hold your AGM within Canada at the place you dictate in your bylaws or where the directors determine, or if everyone agrees, you can have your meeting held outside Canada as well. And that's specifically stated right in the legislation. So I'm going to talk a little bit about virtual meetings and electronic or proxy voting because there's definitely differences there. And, before COVID, we probably wouldn't even be talking about virtual or electronic. We'd be just talking about proxy voting, which is sort of going by the way of the dodo bird since anyone can sign up for an electronic meeting from anywhere in the world now. But under the Alberta Societies Act, since the act was amended after COVID, I must say, um, the specific provision in the legislation now is that AGMs may be held electronically, i.e., like we're doing here today, um, unless our governing documents expressly provide otherwise. So that means, we can all attend an AGM unless the governing documents of the organization specifically prohibit it. So it's like a reverse thing. It's a free for all unless your organization does not want you to be able to attend virtually. And the Societies Act simply states for electronic voting that members can vote any electronic, telephonic, or other method that the society has made available for that purpose. So these are key. So it's the society that's made the electronic procedure available, not you as the member just deciding to vote in some way. And under the Societies Act, proxy voting has to be authorized by your bylaws. So you see, it's a little bit of a nuance here. The bylaws come in to be very key documents for Alberta societies because the legislation has this reverse onus about electronics. And if you want proxy voting and some method of electronic voting, you should put it in your bylaws. Because the Alberta government amended the legislation pretty well all at the same time after COVID for many kinds of organizations relating to virtual meetings, the Companies Act has the same provision as the Societies Act. Anyone can attend a meeting of a Part 9 company, an annual general meeting of a Part 9 company, unless the governing documents of the company provide otherwise. And again, if the company has made available voting for electronic purposes, then the member can vote that way. The difference in proxy voting is the Companies Act has very specific rules relating to proxy voting depending on what type of nonprofit company you are. There's 4 different kinds of nonprofit companies under that act. So it depends on what kind of company you are as to whether or not you can have proxy voting and how you have to do it. The Canada Not-for-Profit Corporations Act had been amended before COVID anyway, or had been enacted as a modern statute, and they always had electronic voting by means of a telephonic or electronic or other communication facility that permitted all participants to communicate adequately with each other during the meeting if the corporation had the technology available, unless the bylaws provided otherwise. So just like the other statutes we're dealing with, the Canada Act allows you to opt out of having these kinds of meetings if you put it in your bylaws. And I'm certainly, when I talk to organizations about this, I say, maybe you might want the control of these meetings, whether to have them virtually or not, at the decision maker level, the board level. So you're not making anyone able to sign in from anywhere in the world. You're restricting what kind of meetings, members meetings and directors meetings for that matter, you will allow to have virtually, and what kinds you want in person. So keep the control at the governing level of the organization for these kinds of meetings. And you have to do that in your bylaws. The difference in the Canada Act under proxy voting is interesting. They have very restrictive proxy voting rules under that act. If you allow it in your bylaws, if you allow proxy voting, then you bring yourself into the provisions of the Canada Not-for-Profit Corporations Act, which are very prescriptive, and their electronic voting rules are codified right in the statute. So if you want to have electronic voting at your AGMs, then you have to have these criteria. Your bylaws have to allow it, and the system that you're using has to ensure that there's an anonymity and verification capabilities. And you could have electronic ballots, and you can have mail-in ballots for absentee voting if your bylaws authorize it. So that act actually puts a lot in the act, and sometimes if you think it's a good modern framework, some organizations that are societies or Part 9 companies look at the framework that's in this modern legislation and they adopt it as best as they can in their bylaws for their societies or their companies. So it's very modern, but it's very prescriptive. So here we're getting to your question. Who can attend an AGM? That depends. What legislation are you incorporated under? So under the Societies Act, all your membership and your attendance rules are set by your bylaws. So to get to your question, if you have a non-voting class of members in your bylaws, because that's where you have to create them under the Societies Act, then you can put in your bylaws that they can attend the meeting, the annual general meeting, or you can put in the bylaws that they cannot attend your annual general meeting. So very key, the rules of your AGM have to be in your bylaws. So you have to have some sort of a governance process around the AGM. Because why? Who's the AGM for? The AGM is for the members who can come and vote. The Companies Act specifies that the notice, regardless of who your members are, the notice has to go out to all shareholders. And under the Companies Act, you can have members and shareholders. Members, directors, and the auditors have to get notice of your AGM under the Companies Act. And it's the same under the Canada Not-for-Profit Corporations Act, except it goes a little further. Under that act, your members, directors, and your auditors must receive notice of the act, and they're entitled to attend the AGM. So you cannot keep these people out of your AGM if you're under that act, no matter what your bylaws say. Bylaws sometimes in societies and companies and Canada, not-for-profit corporations, often deal with how observers come into your AGM, guests, staff members. You know, they're not, unless they're members of the organization, they're not automatically entitled to attend. So it's very key that your bylaws and sometimes your policies made in pursuant to a bylaw provision that talks about these things dictate who can attend an AGM. So it's not one of these, well, everyone knows who's going to attend an AGM. That's not the answer to the question. The answer is it's in your act that you're incorporated under, or it's in your bylaws or policies. So I hope that answered the question.
We do have someone who's asking, and I'm sure there's more than one person who's trying to understand what is a member? Like, how do you define a member?
Okay. Well, every single act that I'm talking about talks about the members are the most important people in the whole structure. So the Societies Act, you must say in your bylaws, who are the members of your organization? How do they get admitted? Can they withdraw? Can they be suspended? The Companies Act has a different kind of a framework. Usually it's the subscribers to the memorandum are your first members, and they admit other members as they go along, as the organization moves along. The Canada Not-for-Profit Corporations Act has very specific rules about having members. You must have members in all of these organizations. So members are people who come in and, or they could be corporations. Sometimes corporations are members of societies or companies or Canada Not-for-Profit Corporations. These are the basic people. They're sort of, if you put it in a business kind of analogy, it's sort of like the shareholders. Members are like the shareholders of companies. So the shareholders don't spend a lot of time at the business of the organization they're shareholders of, and the members don't spend a lot of time at the organization. They come to the annual general meeting and they do other governance tasks that are assigned to them depending on the statute that you're incorporated under. This is fundamental. I do a lot of sessions on basic governance of nonprofit organizations. I do it for board leadership events around the province and for individual organizations and integral org. We have our clinics where we explain all these things to anyone who needs the information. Basic governance 101 stuff that you're asking. It's very important that you understand, because when things go wrong in an organization, it's often because something has not been followed in the legislation or the bylaws, or people have ignored something fundamental in their legal framework. And an often overlooked thing is, who are our members? Because they're the ones that come to the AGM. Okay, more questions?
We have one more
Okay.
question
Okay.
in relation
Good.
to who can attend.
Yes.
And it is,
Mhm.
if the bylaws say only members can attend the AGM,
Mhm.
then can the ED,
Mhm.
Executive Director / CEO, attend?
Well, if the bylaws say only voting members can attend, then only voting members can attend. That's what the bylaws would say. If that's what they say, it's that would be very rare. But who would chair? Sometimes the chair of the board, maybe they're not a member. Maybe the directors are members as well, and they're all there, but they're not there as directors, they're there as members. Some bylaws say the chair or the president of the organization chairs all members' meetings. And then if that person is a member, obviously they're in the meeting as a member and as a chair, but if they're not, they're just there as a chair. So these are good questions, because you want to be ready if someone says, well, I'm coming to your meeting, and you want to be able to say, no, only voting members can come to our meeting. This is what our bylaws say. Because that's who the AGM is for. Okay? The AGM isn't for your friends, the AGM is for the members. It's an annual general meeting. And a general meeting is generally meeting of the members. Some foreign concepts, I can tell. Any other questions there before I go on to quorum, which is another misunderstood?
So, yes, a couple of questions here. One is, should directors be members? The society I am a board member of has no members.
Well, the society if it's an Alberta society incorporated under the Societies Act, it has members. It has to have members. Read your bylaws. Your bylaws specify who your members are, and if it doesn't, the bylaws would be rejected by Alberta Corporate Registry, because it would not be in compliance with Section 9, subsection 4 of the Societies Act, which must state, how do members become members, how do they get admitted, etc. So very key, but potentially, all those directors were admitted as members first Maybe they didn't understand that they were members. Societies go on for a long time before a problem happens, and then they realize that they need to know who their members are. So it's good to know if you find this out now, then when trouble starts, you'll know. And if it's the directors, they're members first, then they're directors. Or your bylaws might say the only people who are members are those elected directors by the members. And if you look at the Societies Act, it's very logical. Those 5 people that sign the application for society, those are the first members of your society. Okay, let's go on to quorum because that's key. What is a quorum? A quorum is a very important, term, and it really means in this context, it's the minimum number of voting members who must be present at the meeting. And in today's day and age, either in person or electronically, before the organization is allowed to conduct official business. No quorum, no meeting. It's just a social time. So quorum is different in each legislation too. So under the Societies Act, how do you know what your quorum is? Well, you must define this in your bylaws. Your Societies Act bylaws must state how many members make up a quorum for your members' meetings. Some bylaws have a different quorum for annual general meetings than they do for special meetings. So you need to know what your quorum is for your annual general meeting. The Companies Act specifically says unless you say in your articles of association what your quorum is for members' meetings, then if you're a private company under that act, it's 2 members. That's your quorum. And if you're a public company or any other kind of company, it's 3 members. So the act is a default. And in the Canada Not-for-Profit Corporations Act, they've come up with a formula. You have to set it as a fixed number of members, a percentage of your members, or you have to put some sort of formula in there so you can determine what your quorum is based on an exact formula that anyone would be able to calculate. So very important. Quorum is key. Because if you don't have quorum, you're not legally constituted to have an annual general meeting. So you're in your annual meeting. What must be done there? Well, under the Societies Act, the only thing the Act says is that at the AGM, you must present a financial statement setting out the Society's income, disbursements, assets, and liabilities audited and signed by the Society's auditor. Now, under the Societies Act, your bylaws will specify how you get an auditor, just so you know, that's key. But everything else about how an AGM is conducted, you'll find in the bylaws. You should find in the bylaws. And if they're not in the bylaws, then there's probably some sort of policy or procedure that has been made over the years that hopefully has been adopted formally that you follow for your AGM. But there's not a lot that the Societies Act requires you to do, except you must have an annual meeting. So what must be done at an AGM if you're an Alberta company incorporated under the Nonprofit Companies Part 9 section? Well, again, the annual general meeting must receive financial statements, and subject to the articles, they appoint the auditor unless it's waived. There's various waivers you can use under that act. Everything else about how an AGM is conducted can be defined in the Articles of Association. The Canada Not-for-Profit Corporations Act is a little bit more rigid. It has rules, more rules than our Alberta statutes. If you're a Canada Not-for-Profit Corporation, then the AGM must receive financial statements and the public accountant's report, and the AGM must appoint or waive the appointment of a public accountant. That's the modern term that this act uses for auditor. And under the Canada Not-for-Profit Corporations Act, you must have elections. If you require to elect directors in any given year, you must have elections. But everything else about how an AGM is conducted under that act can be defined in your bylaws. So you're getting that bylaws are important here. They seem to answer all your questions that you're asking anyway. So how do we amend our bylaws? So, if you want to have a procedure about your AGM and you want to deal with some of these quorum issues and things that we've talked about, who can attend, all these wonderful things that you've asked questions about and I've stated, and there's many other nuances about AGMs that you could be concerned about, you should be concerned about, and you could put things in your bylaws. How do you amend your bylaws? Well, under the Societies Act in Alberta, your bylaws can only be amended by a special resolution of not your directors, it's your members. Your members have the special resolution, and that's defined as a resolution that people have received 21 days notice specifying the intent to amend the bylaws. At the meeting where the voting is happening, 75% of those members there who vote in person or by proxy, if you permit proxies in your bylaws, 75% of those people at the meeting have to vote in favor of the special resolution. And they can be passed unanimously in writing by all members. If you only have a few members, you don't need to call a meeting to do a special resolution to amend the bylaws. Everyone can just sign a unanimous written resolution in writing. And once you've done your meeting or your written resolution under the Societies Act, you just can't walk away. You need to file those bylaws with Alberta Corporate Registry before they take effect. So that's key. That's how you amend bylaws under the Societies Act. Under the Companies Act, how do you amend your Articles of Association, which remember I said are sort of like your rules, your bylaws, but using the old terms. Again, you need a special resolution. Same kind of definition. The only difference between the Societies Act and the Companies Act in the definition, and it's not on the slide here, but you can also do a special resolution at a special meeting under the Societies Act, but you can't under the Companies Act. I don't know why that historically has been carried forward, but you have to make sure you're at the right kind of meeting, depending on what kind of act you're incorporated under if you're doing a special resolution. And amendments must be filed with Alberta Corporate Registry. And just one question that probably might arise in the chat is, can you do a special resolution at an annual general meeting? And the answer is yes, you can, if you've given the proper notice. So even if, let's say your society's bylaws say you could have an annual general meeting with 10 days notice of meeting, if you're doing a special resolution at that annual general meeting, such as amending your bylaws, then you still need to give the 21 days notice of the fact that you're going to ask for a special resolution to amend bylaws at your annual general meeting. So don't get tripped up by that, thinking, well, we'll do it in an annual general meeting. We only have to give 10 days notice. If you're doing a bylaw amendment or anything else that requires a special resolution, and there are a few things under all of these acts, then you must give the proper notice. Under the Canada Not-for-Profit Corporations Act, the bylaw amendment process, it differs depending on the wording in your articles of incorporation. Or the bylaws sometimes. They give different rights for members to amend bylaws, different rights than the Societies Act or the Companies Act does in certain respects. And under the Canada Not-for-Profit Corporations Act, certain kinds of corporations can have a unanimous members agreement where all the members get together and agree on many things that ends up governing and affecting how the corporation operates. So you have to really be careful about amending bylaws under the Canada Not-for-Profit Corporations Act. But a common process under this act is for, and it would be specified right in the bylaws, is for the directors to first approve any bylaw amendments, but then they must have those confirmed by the members of the corporation. And sometimes in the Canada Act, there's class voting rights. And that's a very complicated situation to explain. But you have to, if you're a Canada not-for-profit corporation, you need to understand the difference in voting rights if you've created different classes of members in your articles of incorporation.
So we have
Mm-hmm.
a question.
Mm-hmm.
And it is about the Societies Act. It
Okay,
says,
good.
if you are under the Societies Act,
Mm-hmm.
the president was told bylaws are not effective
Mm-hmm.
until corporate registry files them, which can
Mm-hmm.
take up to 6 months.
Okay, well that's true. It can take, well, maybe not up to 6 months. They're getting faster. However, they're effective the day they're filed and accepted, but you don't get them back from corporate registry for months. So it's kind of one of these weird Alberta things. So if we have our annual general meeting and or a special meeting or pass our special resolution today and everything's fine and I file it in corporate registry tomorrow, the stamp will be tomorrow's date, even though I might not get the paper copy back for months. So this is one of these weird things. So they're effective the day they're filed. Maybe one day we'll modernize here in Alberta. Does that answer that question? I hope. It's a good one.
Yeah, I think the person replied, thanks. So we're good.
Yeah, the Canada Not-for-Profit Corporations Act, whew, it's right in, immediate, comes back. But there's no provision in there that it's effective only when accepted, like our Societies Act. So again, different statutes. So and under the Canada Act, all amendments must be filed with Corporations Canada, but it doesn't say that they're only effective when they're filed. They're effective when the members confirm them. And then the CNCA, the Canada Not-for-Profit Corporations Act, has a wonderful proposal mechanism if members want to uprise and change the governing structure, the bylaws. So that's something to keep in mind if you're under that act too. You don't want that to be happening at an AGM. Too disruptive. Boy, how are we doing for time here?
Yeah, it looks like we have 15 minutes left.
Good. Okay, good. Well, I'll quickly go through some of my checklists then. So, but my overall commercial is how do you avoid disputes at your AGM? Because disputes happen. You know, if there's a court case about a society or another kind of not-for-profit corporation, it's often something about the AGM. But first of all, follow your legislation. Know what you're incorporated under. Read your bylaws. And if you're a society, the ones that have been filed and accepted by a corporate registry, and follow that procedure exactly. And if the procedure is not good in the bylaws, amend them. Start your review process and get good bylaws so you won't have these disputes. Ensure your elections, if you have the elections at your AGM, which most organizations do, ensure that these elections are fair, transparent, and well documented. Your procedures, what happened, all these things well documented. Then if there's a dispute, at least you have some evidence of what you did. Of course, give proper notice. Remember, each act seems to have a different notice provision, depending again on what your bylaws say, with complete information. Not, special resolutions, you have to literally give the information about the resolution, or else that's not proper notice. And of course, technology, use reliable technology and make sure that you're following any rules of your organization or your legislation. Remember that Canada Not-for-Profit Corporations Act had those prescriptive things about electronic voting. And prepare your members in advance if you're going to do virtual meetings. I mean, today's day and age, you're still running over into people who don't feel comfortable with this technology, and you don't want any disputes that the people couldn't get in the meeting, things like that. And maintain strong documentation. Of course, that is the only evidence in a dispute. Your documents, what happened, what you did, the minutes. We'll talk a little bit about that in the checklist. So that's, if you do all those things, you should be fine. So any more questions before I start whipping through my practical strategies for effective AGM checklist?
We do have a question related to non-compliance, and it says,
Yes.
who within the Alberta Societies Act
Mm-hmm.
can we connect with
Mm-hmm.
for non-compliance? So I'm assuming that's
Yep.
non-compliance with
Yes.
bylaws or, yeah.
Yes. Well, um, the short answer to that is your members have the remedy for non-compliance under the Societies Act. It's not the government, it's the members. And who do the members go to? The courts. The courts have an overriding sort of a babysitting role for societies. You should be thinking expensive. You should be thinking, let's try to iron this out first, right? But generally, there's no police. It's the members. The members are the ones who can enforce the bylaws. Why? Because the bylaws are for the members. And under the Societies Act, the bylaws tell the members how the society is operating, how it's going to be governed, to make you comfortable to sign up as a member. So some of the court cases will treat the bylaws as a contract between the society and the members. So it's like you're getting into a relationship. So what is your relationship? You're a member, and how is it governed? The bylaws. So there's no big police out there. You're on your own. So, before you join a society, maybe make sure the bylaws, make you feel comfortable. Certainly if you're going to be a director, I would say that, but even if you're going to be a member, if it's important to you, read the bylaws, make sure you're comfortable. If not, well, then take a pass or get active and get them to amend their bylaws to make you comfortable as a member. Hope that answered that question. Okay, good. Well, some quick things. Again, just a review of what we've done. But if you do all these things, if you, first of all, know what your incorporation is, follow the timing requirements in your legislation, for sure, that's key, and confirm your electronic meeting rules, different under each act, or in your bylaws, figure it out, confirm. Make sure your bylaws actually support what you're going to do, your format of your meeting. Remember, the Societies Act now says anyone can go virtually unless the bylaws prohibit. So if you don't want a virtual, then you better put your bylaws saying no virtual meetings unless the board approves or some other mechanism. Ensure that your bylaws clearly set out your mechanism for membership. This is so key. I mean, every piece of legislation insists on it, and it's important that you know, in case there's a dispute, who your members are. What are their voting rights? What is the quorum? And what is the procedures that are going to happen in your AGM? If you have a special resolution or bylaw amendments that require a special resolution, make sure that you're meeting the appropriate notice and approval requirements. Don't forget to file them, because that's not a good idea. Okay, financial preparation. I'll just give a commercial for all my friends who are accounting professionals out there. Provide financial statements to members in advance of the meeting. It's required under the Canada Not-for-Profit Corporations Act. And make sure that the financial statements are complete, they're signed, they're ready for presentation, and give the accountants some airtime at your AGM. Prepare a presentation for your members so everyone knows what's going on. Very important. Elections and nomination procedures. Make sure you have some sort of a process, a nomination process, some way to confirm your actual voters, which members are going to vote, etc. Potentially use a nomination procedure. Prepare clear instructions as to how someone's going to get elected and what procedure is going to happen at the annual general meeting. and follow your bylaws, not the organization that you went to their AGM last month. Follow your bylaws, very key, and your policies or procedures if you've made them in pursuant to your bylaws, and to have a smooth meeting. Make sure you send out your required notice within the time period. You don't want someone standing up at your meeting say, I didn't get a notice till yesterday, and then have to prove it. That you actually mailed everything out in time, but your bylaws don't allow you to mail anymore. They want you to do email, so you have to make sure you're following your own notice requirements. That's very key, very key. This is often missed today. Make sure all the meeting details are there. Everyone knows where they're going or where they're signing on. Make sure that your members know how the AGM will be run, who will be there, for example. Potentially allow them to ask questions in advance if they see something on the agenda they don't understand or they want more information on before they get to the meeting and start making a fuss. And if you've had any membership problems over the year and you have had to remove members in accordance with your bylaws, then make sure that you follow the process, because you don't want any of this brought up at the AGM. It's not a fun scenario. Technology, make sure you're ready. Test your platform, as we all do now with our Zoom webinars, etc. Make sure your voting technology is in accordance with the legislation or your bylaws, depending on whether you're a Canada not-for-profit or a society or a company, and potentially give some people a chance to learn how to do it before they have to vote. And backup systems. I mean, what if the power goes out and we all have to run our AGMs by cell phone? Potentially that might be something you need if it's an important meeting. I mean, yeah, you don't want to go overboard on all these things, but if it's important to you, then it's important that all these things are complied with. Quorum. Make sure you know what your quorum is. There's nothing worse than going to a meeting and someone says, what's the quorum? And someone says, I don't know. Are we all here? No, that doesn't work. You need to know what your quorum requirements are, because you can be darn sure that if someone is in the audience and they want to make a fuss, they're going to know what your quorum requirements are. And they're going to challenge you on it if you don't have a proper answer. Have some sort of way to track people who are in the AGM. And if they're supposed to be there, then they should be able to sign in or register, and have someone tracking all this and making sure people are eligible to vote. Minute taking, just a quick word on minute taking. Someone should be taking minutes, the corporate secretary. Prepare a script for the chair. That's a really good one. So the chair just has to read and take the motions, and everything is planned out so there's no glitches. Record the attendance, do all these wonderful things. So you all have documents of what was happened. And finally, draft minutes should be prepared promptly while people remember, and they're approved at the next AGM or the next members meeting, depending on what your procedure is or your bylaws say. So that's it. I think I've gone over time, so
No,
I'll have to turn it over.
You're
No, we're
still
good?
doing really
Okay,
good.
that's good. Okay, well, I'm pretty
Um,
well at the end, and now I'm happy to take questions.
So
How's
one
that?
question that was
Mm-hmm.
posed, and then
Mm-hmm.
other folks had thoughts about it,
Mm-hmm. Okay.
was, if I understood correctly, the
Mm-hmm.
Societies Act says AGMs can occur in an electronic way,
Mm-hmm.
but a society's bylaws need to specifically speak to and allow electronic voting. And then related,
Mm-hmm.
someone has noted, didn't Avon also say that electronic voting was allowed after the Societies Act amendments
Yes.
in
Mm-hmm.
2022,
Yes.
as long as the bylaws don't directly say that it's not?
Correct. That's exactly what I said. So the legislation just changed in Alberta in 2022 to say, I think it was 2021, 22, to say that everyone can vote and attend electronically unless the bylaws say otherwise. So So that's why I'm saying that it's such a loose clause, a loose piece of legislation. It puts all the power into your organization to make sure you have a made for you process for your AGM, your meetings, everything. Do you want it electronically all the time? Never. Sometimes when you permit it. Do you want voting? Yes, no. I mean, you guys take the control, and don't let it be open, because if it's open, then it's a free for all, and anyone can attend. I mean, there have to be members, obviously, but sometimes this costs money. You don't want to have to set up hybrid meetings all the time just in case somebody wants to sign in from Timbuktu because they don't want to come back to Alberta for their meeting. So that the second answer to the question was the correct one. Your bylaws need to specify everything. Otherwise, it's a free for all pretty well.
Wonderful. Okay, I think we will move on to our closing slides here.
Okay, good.
As Yvonne mentioned, we just want you all to know that there is an opportunity at Integral Org for a free legal clinic. And that's an opportunity to chat with a lawyer, was typically Yvonne, to ask questions and get some thoughts about a legal issue related to your nonprofit. So it could be any legal issue, but it also could be specifically about your AGM if you're wondering about some of the information that we presented today and you're not sure. I would like to very sincerely thank you all for being here today. And I'd like to thank Yvonne as well for sharing her expertise. And we hope to see you at another webinar in the future. Thank you so much.